The only other concern that I would like you to clarify on, and this is the crux of the matter for me in this regard, is you yourself testified, you've been internationally recognized. I don't take that away from you, and I don't question your opinion in any manner. However, it is your own words when you were asked to read that section. It's extremely wide. The Act doesn't define. The Act doesn't define possession. The Act doesn't define. But you can't limit yourself to give your view based on the set of facts we are dealing with here today.
Your Worship, in 2022, the Constitutional Court gave a decision relating to certain provisions of the Firearms Control Act. And in that decision, they referred to a reasonable and business-like interpretation of legislation. I'm guided by that as a legal practitioner. So in my opinion, the version postulated by the state in the formulation of the charges is neither reasonable nor businesslike in the circumstances of this case. That is my opinion.
In a nutshell, in your view, the section 120.10a, then null and void.
No,
No,
Your Worship, we all need to take into account that we can't quote the section piecemeal. It says who is not allowed in terms of this Act to possess that firearm or ammunition.
Yes.
So it's linked to a very specific requirement.
Yes, exactly. I agree. So, do you have an opinion on the set of facts that you've been, I'm sure, presented with during consultation by the defense? Because I've not heard you on that aspect.
Your Worship, I do not know the full facts of this matter. I have not seen the video for a number of years. That was not the purpose of me being called to give evidence.
So I'm going to leave it at that. Thank you, Mr. Woods.
Excuse, please.
No, not yet. Sorry, there's a second phase to this. Advocate Matthews, questions based on the court's questions?
I refer you to the further particulars in the matter. Bound itself. These are the facts. The state has bound itself to the handing over of the firearm by accused number 2 to accused number 1. You understand that is? And I've referred you to the section 174 where Her Worship said in her judgment that sure, there is no evidence that there is a physical handing over of the firearm, but because the section says may give possession in any other manner. All right. Now, I fail to understand what other facts you've been given. The Worship is asking you to show that the firearm was handed over in any other manner. Have you been given any other fact?
I think he was quite clear on that, Advocate Matthews, that he was not at the end of questions by court.
No, the guest of the Worship's question is a little bit different to mine with respect. The state is bound by what it says in its further particulars that there was a physical handover of the firearm. All right. The fact is, there's no evidence as to that before this court. You understand? I do. Now we're going to this interpretation of this or in any other manner gives possession. And Her Worship in the judgment says because he was the owner of the company, all right, that means that in any other manner he gave him possession.
Sorry, can you just refer to the page where I said he was the owner of the company? I just need to update myself as well. Thank you.
Yeah, paragraph 20, page 25 of your ruling, line 19. The firearm in question being SAP 249-14 is indeed your firearm.
Yes.
Or the company's firearm.
So the word being the owner of the firearm was not uttered by court.
The firearm in question being SAP 249 is indeed your firearm.
Did I use the word owner?
Or the company firearm.
Did I use the word owner?
No.
Thank you.
Right. That is the words used by the court. Your firearm. Or the company's firearm. Now we established that it's not his firearm. All right. Yes. And the firearm belonged to a close corporation, as you understand. Yes. All right. Now the mere fact that the owner, in brackets, might be present on a scene where somebody uses a firearm belonging to the company, would that mean that in any other manner he supplied it to? No. Thank you.
Thank you, Advocate Matthews. Advocate Odes?
Bishop, I have a few questions.
Certainly.
Arising from the Bishop's questions that they relate to the ammunition. The Bishop asked you whether the ammunition for these blank firearms is available to buy in South Africa. Do you remember that? Yes. Now, what I want to put to you, sir, is that usually the blank firearms and the ammunition are sold together at the same type of retail stores. Now, you also said that you don't need a license to purchase these firearms, you wouldn't need the competency to purchase a blank shooting firearm. I want to put you that the same would stand in relation to the ammunition. One doesn't need a license or a competency to purchase the blank ammunition. Is that correct?
Well, correct, and in fact, technically, according to SAP's ballistics, it's not ammunition.
Yes.
Well, I have an issue there, and I want to show it to you because everybody's handed in or had regard to Exhibit L2, and there seems to be some uncertainty in that regard. If I may refer you to the last page. Do you have it before you?
Is that the Cox?
The advocate, Rodney Cox.
For some reason, I don't have the last page.
Well, it doesn't seem to have a last page. But if
Mine ends at paragraph 18.
The other one that I have as well. No, I've only have it up to 18, so I have this from my learned friend for the state. But if you look at paragraph 17, it's been circled by somebody, the DPPs are also of the view that even though the blank ammunition can technically be regarded as ammunition, in terms of the FCA, that the possession of such ammunition cannot be prosecuted based on the fact that the general public is informed that no license is necessary to possess such. So my question to you is, you said that, and I understood your definition of ammunition being ammunition that actually sends out a projectile. Here, this ammunition doesn't have a projectile, so but they say technically, even though it might fall within the definition, it's not an offence to possess it.
That's the Directorate of Public Prosecution's opinion. SAP's ballistics have issued a directive saying it has to have a projectile in order for it to be ammunition, to fall within the definition of cartridge as set out in the Firearms Control Act with those four components: primer, propellant, case, bullet.
Now, my next question, sir, relates to the more recent debate that took place. If one has regard to count 6, and I'll read it through, that's the section 120 sub 1 sub A. And to read it in its entirety to you, and I need to tell you up front, it only applies to accused 2, but it makes mention of accused 1, so that's why I want to make that clear. So it says here that count 6, accused 2, that the accused is guilty of the offence of contravening the provisions of section 120 sub 10 sub A. We have the sections 1, 103, 121A, it's section 121, read the Schedule 4 and Section 151 of the Firearms Control Act 60 of 2000, and further read the Section 157 of the Criminal Procedure Act 51 of 1977. Then they identified as providing a firearm or ammunition to any person not allowed possessing it. Now I need to clarify this because they say further here, when they explain it in the body of the charge, and that upon or about the 28th of July 2018 at Adon Yasisa Dukazi Stadium in Bansani in the Regional Division of the Eastern Cape, the accused did unlawfully supply or in any other manner give possession of a firearm and ammunition to wit a .223 Narinka rifle and or a firearm, the make of the firearm unknown to the state, and a .223 Remington bullet to Julius Malema, being a person who is not allowed in terms of this act to possess that firearm and or ammunition. Now, I understood your evidence, and this is why I ask you this, to be a person who is not allowed to be in terms of the act in possession of the firearm and ammunition. On your reasoning, as I say, you must be a person who's been declared unfit to do so. Would that be accurate?
That's correct, yes.
Now the reverse, or not the reverse, the facts of the case as put to you were that accused number 2 has never been declared unfit to possess any type of firearm. Could that then apply on your interpretation of Section 120 to these facts in this matter?
If I understand your question correctly, and to put it in simple terms for me, are you suggesting it would be lawful for one accused to supply the other accused the firearm? Is that what your suggestion is?
I'm not suggesting. I'm using your evidence just to explain. As I understood,
I don't have the charge sheet in front of me.
I'll hand it to you. As I understand your evidence, and this is the point, is that possession is very, very wide, and you said in order to not be allowed to possess, because I can give my firearm to somebody else to shoot, but to make it an offence, that the person that I give it to would have to have been declared unfit to possess.
No, what I said was, in these circumstances as presented to me, because Mr. Snyman was present, then he, on the version of the state, and I want to emphasize on the version of the state, could lawfully hand that firearm to anyone in his vicinity where he could exercise control over that firearm.
I understand that. My point is the following story. He could hand it over to anybody, and I put you, except a person who's been declared unfit to possess such a firearm, because that person by law is not allowed to possess such a firearm.
Yes.
So let's use the version of the state, okay, as was put to you. On the state's version, accused number 2, it goes against the further particular, but on the state's version, accused number 2 handed over a firearm to accused number 1. Accused number 1 is not declared unfit to possess a firearm. Is there anything improper or irregular in doing so in his presence?
Under his control, no.
But I emphasize that's the state's version.
It's a hypothetical.
We've all got different, the same view of the video, which doesn't substantiate the state's version. But if you saw a video, let me put it like, if you saw a video of accused number 2 handing over a firearm to accused number 1 who had not been declared unfit to possess a firearm, would there be anything untoward or illegal in him doing so?
No, as long as the person handing over the firearm was in his presence and exercised control.
Thank you. That's how I understood you, and that's what I wanted to clarify. Thank you. Thank you, Ashok.
Thank you. Any questions based on the court's questions?
Just wanted to, you wanted to state earlier what is the 4 type of competencies you got for different type of firearms. You said there are 4 types.
Handgun,
Yes.
shotgun, manually operated rifle,
Yes.
semi-automatic rifle, pistol caliber carbine.
Is it correct that you have to go for training to get the competency in respect of each of that type of firearms, except for the revolver and the handgun? They go for the same competency, is that correct?
Well, the training doesn't distinguish between types of firearms at all. So it's a rifle, it's a handgun, it's a shotgun, and it's a semi-automatic rifle or pistol caliber carbine. So you don't talk about a revolver or a handgun.
Yes. But the fact of the matter is they are not the same. The handgun, the competencies for the handgun and the rifle are not the same.
No, the training is different, yes.
I didn't hear your answer.
The training would be different, yes.
Correct. I did training for a handgun, a semi-automatic handgun. Can I now use that same competency certificate in respect of a rifle?
No. However, you do not need a competency certificate to use a firearm under the supervision and control of the license holder or someone authorized by the license holder.
And in the scenario, the firearm still hands it
Yeah,
with people there.
is probably an offense. Yes, I would agree with you.
Thank you.
Thank you, Mr. Woods. We have finalized your evidence. You are excused and you may stand up. Okay, just 1 second.